Association of Certified eDiscovery Specialists. My name is Mike Quateraro, and I am the president of ACEDS. Today, we are joined by our partner, Conduent, for a webinar in the 2023 eDiscovery Best Practices Series, Embracing Technological Advancements While Honoring Time-Tested Fundamentals. We'll get to our presentation in a moment, but before we get started, please know that we love questions. We're happy to take questions, and you can submit your questions using the Q&A widget located on your screen. All questions are anonymous. Also, if you'd like a copy of the slide deck, it's brief, but it's powerful. You can download it in the resource widget located on your screen. Alrighty, without further delay, I'm super excited to introduce Sean Oak, who will take the presentation from here. Sean, please take it away.
Thank you, Michael, for having us, and a big thank you for ACEDS for hosting this webinar. I'm Sean Oak, the Senior Director of Delivery for Conduent Litigation and Compliance Solutions. Conduent is a global provider of BPO services, including end-to-end eDiscovery, analytics, and document review, and have been in this space for 20 years. I, myself, have spent 17 of those years with Conduent on the eDiscovery service provider side, a variety of roles from leading project management teams to managed review operations, and now leading our processing hosting operations. And now, without further ado, I'd like to introduce our panelists, for which I'm excited for a very lively conversation today. First, Stephen Arena, founder and partner at Trachtenberg Arena. Please tell us a bit about yourself.
Well, first, thank you for inviting me to be part of the panel. Thank you to ACEDS for having this webinar. Should be very interesting. As you said, I'm a partner at Trachtenberg Arena. Trachtenberg Arena handles a wide variety of commercial matters, large and small, for both plaintiffs and defendants. So we see a wide variety of cases come across our desks. Prior to being a litigator, I was a transactional lawyer in the capital markets department at a large firm. And prior to that, I was a software developer and consultant at a large technology company.
All right, excellent. Thank you, Stephen. And now on to Stefan Dooley, a Director of Electronic Discovery and Litigation Support at Sullivan Cromwell. I know you're having some tech issues on the video side, but we're happy to have you via audio if you want to give us a brief overview of yourself and how you approach this topic.
Hey, thank you for the invite, Sean. Pleasure to speak with both you and Stephen to kind of talk through this fun issue or this fun topic. Apologies again for the camera fun stuff. Stephen's a better looking one anyway, so I'm sure none of you will miss out on me. And Sean, no credit. I'm not going to discount Sean either. So I've been at Sullivan Cromwell for about 16 years now, going on 17. If you saw me, you'd see the gray hair that manifests the 30-plus years of experience in the industry. Go way back with a lot of our friends in this space. That's what kind of attracted me to this topic in the first place. Obviously, SMC manages a vast variety of different types of challenging matters. So we run into where new technology meets the fundamentals, the sniff test, if you will, of our process on a daily basis. So look forward to talking this through.
Excellent. Thank you, Stefan. And now onto the overall topic of embracing technological advancements while honoring time-tested fundamentals. So in the ever-evolving landscape of eDiscovery, cutting-edge technology advancements and AI-driven solutions have shaped workflows and processes. However, despite these transformative impacts, we must not forget to recognize that eDiscovery fundamentals remain a critical foundation. On this webinar, we explore the relationship between technology and traditional eDiscovery practices and the importance of leveraging both to drive efficiency without sacrificing defensibility and the integrity of the underlying process. So as we discuss this topic, it's good to keep in mind the relevant rules that guide how we approach discovery when it comes to the four core principles of eDiscovery, which is identification, collection, review, and production. While there have been various advances in the technology that have impact in each of these areas over the life of eDiscovery, it is helpful to keep in mind the framework of reasonableness and defensibility that are laid out as part of the duty to disclose. Stephen, as our resident lawyer on the session, do you want to quickly run through this topic for us?
Sure. Yeah, I'll try to quickly take us through those four major steps in discovery and hopefully be able to hit on a rule and a couple of cases along the way. So let me start with identification. What are we doing there? We're trying to find the data. Where are the documents? Where's the relevant information? We'll likely be conducting client interviews, trying to identify custodians, maybe even interfacing with IT and technology folks at the client. Well, what's our duty number one with respect to identification. I'm going to quote from a case, Fendi Adele versus Filene's Basements, a Southern District case from 2009, where the court had stated, it should not require reiteration that litigants have an obligation when discovery is sought from them to make reasonable efforts to locate responsive documents, including setting up reasonable procedures to distribute discovery requests to all employees and agents. So, as you'll hear multiple times, we have to operate reasonably. So we have to, with respect to identification, we have to make reasonable efforts to identify and ultimately produce responsive and non-privileged documents. With respect to collection, review, and production, the federal rules and the decisions don't specifically dictate granular workflows or methodologies that must be done. Rather, as the case law tells us, there's a deference to the producing party. I'm referring to cases that I'm going to refer to here as the Hiles case, which I believe is identified on the slide. This is a Judge Peck case from magistrate judge from the Southern District from 2016, where he states, citing to the Sedona principles, that responding parties are best situated to evaluate the procedures, methodologies, and technologies appropriate for preserving and producing their own ESI. That case was with respect to TAR, which we'll get to on the next slide, but that general principle of deferring to the producing party with respect to how they're going to carry things out is something that's applicable to discovery in general. In fact, the judge refers back to a tax court case where he explains the court is not normally in the business of dictating to parties the process that they should use when responding to discovery. If our focus were on paper discovery, we would not, for example, be dictating to a party the manner in which it should review documents for responsiveness or privilege, such as whether that review should be done by a paralegal, junior attorney, or senior attorney. What the court does require, as the decision goes on to state, is that the standard is not for perfection to use the best tool, but it has to be reasonable and proportional. So although the court and the rules do not dictate specific procedures for collection, review, and production, they must be reasonable and proportional. Now, there's the other case that's identified on this slide, which is Nichols v. Noom, actually gets into the issue of, what is the duty for production? And Rule 34 gives us some indication. If there hasn't been an ESI agreement, Rule 34 tells us that the production must be in reasonably usable form. Now, I found that case particularly interesting and topical because in the Nichols v. Noom case, the receiving party brought a motion to compel the producing party to identify documents that were linked by links in emails. So to kind of take a step back, the producing party's emails had links to the Google Drive. And although the producing party produced the Google Drive documents, there was no way to determine what documents linked were associated with the email that was produced. More granularly, there was no parent-child relationship, no family relationship in the production set. And what the magistrate judge in that case, this is a 2021 case, said that the court does not agree that hyperlinked documents is an attachment. So the judge just comes right out and says, well, the link is not an attachment. And what she orders is that the parties cooperate in that the producing party would be required on a case-by-case basis to provide the linked document associated with emails that the receiving party points out. Now, this is, I think, a difficult issue that, I've dealt with it in a recent case. What do we do with links in documents? How do we produce those documents? And this particular judge said, well, really, you just have to provide the ones that the receiving party asks for. But the judge goes further to point out, this may raise some evidentiary and authentication issues, which, it's certainly a concern of mine in this case. In addition, this is a Southern District case. There's other cases out there that take the opposite view with respect to linked documents, that they are indeed, or that they aren't attachments, but they should be treated like attachments, and that parent-child relationship should be maintained. I don't know if Stefan or Sean have had any experience with linked documents, and if they have any workflows or tools that may help resolve some of these issues.
Stefan, would you like to jump in there?
Sure. Yeah, I don't. I think the typical response is depends. I think one of the things that you've brought to light is, while there's an obligation to kind of understand and do things, understand the technology that's in play for your particular matter or your client that you're representing, and there's a reasonableness factor. There's a diligence factor that obviously is a part of the equation of keeping on top of or being aware of industry standards that are out there that do accommodate for anomalies such as this. Now, in our previous world of PSTs and emails, we weren't worried about that as much. There was an expectation that you're going to be able to get the attachments because they're held natively within the containers of the technology itself. Now that we're dealing with things such as links, it's not always clear-cut where that link is going, and the reference to it being an attachment that's been part of the discussion, right? Is it really attached? Is it part of the native component of the document in the email? And you bring to light basically something that certain technologies, Microsoft specifically, has a better tool and ability to kind of navigate through those types of attachments / links, modern attachments. I think that's the appropriate term. And then Google it's a little more problematic if you're collecting Google email or maybe Slack or these other chat collaboration softwares. I've definitely experienced providers out there, and shout out to the ones such as Conduent that are actively out there trying to figure this out and partnering with either the data source providers or with each other to kind of troubleshoot the best way to get to a resolution of identifying substantive information that is potentially relevant, or at least you want to have a look at it to know that it's relevant or irrelevant. And I'm just relying upon that community kind of start establishing some of those workflows. Sean, any thoughts on that?
Yeah, I mean, as somebody who's been on the service provider for years working on these solutions, I would say, right, and we'll kind of keep hearing this same theme, right, as we get into how to apply some of the newer technologies, is really it leans back into that reasonableness, right, and that defensibility. A lot of times you can come up with a solution that may seem like it works, right, but as long as you're making sure you're disclosing, hey, here is how we're operating, right, here are the potential trade-offs, here's the potential limitations. As new data types are introduced, right, it really makes sure you're operating in that good faith. I would say, you can script and you can solution, but really kind of that duty to disclose of how you're operating and making sure it's a defensible process is really the key as these emerging technologies kind of are even more applied, but also as they're introducing new data types. So excellent conversation there. I think that was a great overview, Stephen and Stefan, for kind of why we're leaning into this. So I would say, next up, as we kind of look at eDiscovery in the digital era, I'd say, Stefan, how would you characterize, the impact technology overall, right, has had on eDiscovery? When it comes to tools, right? I mean, as we just kind of discussed, new data types are emerging, but there's also just new tools, right? More data is being processed, more solutions are out there for us to access that data. So how would you kind of characterize that over the life of your career, what you've kind of seen?
Well, being a man that's actually held a base stamp and used it, yeah, I think technology is absolutely, just as you said, impacted kind of both sides of the spectrum, both the technology that we have to go and collect, whether it's the data sources themselves evolving over time, as well as the tools, the technology that's used to be able to do everything we can to, if you look at it from like an info-government space, it's how are we able to preserve in place? How are we able to search in place? How are we able, and these tools are now coming to bear as more functional as you see the development of things like Purview and some of these tools that are coming to market saying, let's be smart about how we carve out the data in the first place. Identify, groups of data that doesn't even have to go into the full processing. So the key is to be mindful of how that, because things are new and shiny and conceptually you want them to kind of deliver this ultimate value of how can I get the data from where it's at to into the review platform and produced in a way that complies with the ESI protocol that you've negotiated. You just have to have a good sniff test around making sure that however those components of the data source and the tools working, that you've got fully processed data that's processed things like the images and or other types of anomalies in data types. So one that's come up rather frequently, again, based on technology, is emojis. Things of that nature. How do you process that? Is that part of the conversation or part of the relevance factor of your particular matter? I've seen matters where that's absolutely the case. And so we're looking towards providers and tools that are going through the process of being tested and true through just machine watching vast amounts of data and just kind of watching for nuance, watching for opportunities where the data isn't fully indexed, which would be problematic for you to fully search it and fully review it in the end. I think one of the other challenges is that with data sources today, we have to get to adjust to the general nature of how it changes dynamically. I think some of the data source providers have been really proactive about building in some governance programs, building in some tools. Again, shout out to Purview for starting to make our job a little easier for considering some of these types of questions. But the reality is there's going to be another technology tool that's going to get used in the next 6 months. And one of your clients will have, especially those that are a little more independent of a regulation, they tend to kind of do all kinds of fun things that they've either built themselves or that are available in the open source community. They're free, but they're generally less governed and don't have as much of a feature-rich dynamic of being able to search, because that wasn't their job. Their job was to sell this very highly collaborative tool that's usable by everyone and makes their job easier and makes them more competitive. So we're going to continue to be faced with these challenges of new data sources and or existing data sources changing in the background. And that just gives us a little bit more, we need to continue to maintain that energy of being in touch with our providers, being in touch with some level of diligence of whatever the way that we collected, Slack data or you name it, type of data 6 months ago. Is it still the best tool? Is it, are there things that have moved and or shifted within the application? And so it's just important to be diligent about that whole process and always test. I'm always a big fan of saying, whatever you're going to do, just put some eyes on a small portion of data, make sure it's a good cross-section of different types of data or different categories of maybe different departments within your organization, just so that you get a nice sense for how the data is going to work. 9 times out of 10, you'll find the real strange stuff that didn't index or didn't process the way you wanted it to. And as you're considering, again, production of anything that's like chat or collaboration data, really talk through what you want to be the ultimate result, because the way you collect and process the data can impact how you ultimately produce it. So that's absolutely a caveat. You want to slow people down just a second to say, before you just go and grab all the JSON files or all the files, let's make sure we're doing it in a thoughtful way so we don't create more risk or more spend down the line.
Yeah, and I think that that's an excellent point to write on how legal professionals can kind of find that right balance, right, between leveraging these emerging technologies and kind of adhering, right, is creating that test and being able to lean into it. I guess Stephen, any quick thoughts on this one?
Yeah, sure. I mean, as Stefan had alluded to, all of these the new sets of data and the new technologies that may be used, everything has to be considered through the lens of proportionality as required through Rule 26 and reasonableness as described in these cases. So although getting it absolutely right is the goal, it may not be possible, or it may not be cost effective, or it may not be proportional to the needs of the case. And the lawyer and the party has to consider that when they undertake some sort of use of some sort of tool or some sort of collection method. And I want to point out, what is the standard for collection? Is it a forensic collection? Is it the most robust collection? And really, it's a moving target because the data sources are moving, the volumes are moving. And I mean, what is a forensic collection? In one instance, we performed what was identified as a forensic collection, and it actually didn't capture the emojis, as Stefan had pointed out. Would we be required to go back and capture those emojis? Is there another tool that could do it? Maybe there is, maybe there isn't. What would be the cost associated with that? So the standard and what's the best practice, all of that has to be considered through the lens of proportionality and reasonableness.
Excellent. Thank you, Stephen. So there's a quick question just about link deadening. Really it's just kind of leaving the link in place, but kind of removing its access out to external systems, right, as you're reviewing. I'm sure we've all seen that. So it's just technology, some providers have built to kind of to go ahead and deaden that. So as you're reviewing or as you're producing it, you're not be able to access kind of those documents, or they go to a dead spot. So Stefan, back to you. What roles have you kind of seen predictive coding and TAR and these emerging kind of LLM models start to take shape in the industry, right? And really help drive not only the efficiency of document review, but kind of that kind of ECA or pre-discovery stage.
Yes, this is very interesting, and obviously a big buzz in our industry right now is the use of LLMs, ChatGPT, Llama, Bard, those types of tools to facilitate kind of this next level of natural language, like conversational ability with information and data. It's exciting. Obviously, millions plus subscribers like in one day or some week or something like that. Everybody was kind of a buzz around it. And I'm sure that everybody's kind of heard about some of the challenges that have existed out of using these tools. And one particular note around, and I won't mention the name necessarily, but there was a sanctionable offense that an attorney had relied upon ChatGPT to actually deliver some content that they were managing in their matter. So those are all things that the typical bumps in the road with something that's kind of new. It shows that it can advance our ability to move through data more efficiently and help with even generative work product. I think what's interesting is I find it fascinating to just kind of understand the risk profile around it. What is a smart way to use it? As with we have had to do with every other tool that's kind of come to market. And we're taking that approach. I think what's interesting is the roles that have started evolving within organizations, right? So you're seeing most firms are developing like an AI ethics committee, right? And they're talking about kind of all the paths of advisory as well as operational support and risk management that these new tools are coming to market with. And there's hundreds of them that are either coming directly to market as AI-driven tools that solve particular business problems, but also our existing platforms, most of your document management platforms, they're all incorporating some level of large language model in these advanced AI tools. So it's good to kind of have this broader lens with kind of this advisory component of attorneys lawyers that are actually looking at the laws that are evolving in this space across the globe, and they continue to evolve. Some of it's a little reactive to identifying, where there's gaps and opportunities for things like bias and other deficiencies that it may lead to because people were relying too heavily on the technology and not testing it. I think one of the fundamentals that absolutely has resonated with me is test, 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 validate, validate, validate. Relying 100% on any of these tools to kind of be the final work product, we still need to develop that level of confidence. I also feel that we're pretty young in the maturation of this type of technology in the legal space, but ultimately there's going to be continued evolution and it will grow pretty rapidly. So I think the firms absolutely invested in it. I've seen several firms go that path, and I just continue to try and look at ways to enhance the team members that are, at least in our team, to be a part of that conversation. Because there's many facets to be a part of.
Yeah, I would say, right, if we look at, the emergence of TAR and TAR 2.0, they were there, and then everybody was using them, right? And as Steve, as you kind of said, right, that proportionality and that reasonableness and that defensibility is with the kind of, growth of data, right, tight timelines, the availability of information, I think these tools are extremely attractive, right? So how you create that balance, right, is really, as you said, Stefan, is making sure you have a process, right? Over my career, right, a lot of times the first thing to do when you're kind of faced with tight deadlines or challenges is to throw out your process, right? Like, let's look for that silver bullet. But really the goal should be to lean into your process and figure out how these tools can augment that, right? And so I guess that's really, a question, right? And I can kind of toss it up to you or Stephen, right? But, how are you leveraging these tools, right? As you say, it's young, even just TAR and TAR 2.0, which aren't on the young side, right? To kind of help validate and determine those risk points in your eDiscovery process, right? If you look at it, how are you utilizing those now? I think you kind of touched on this, but I think that's helpful for people to kind of figure out how to strike that balance between, hey, here's what I'm used to doing. How do I augment and be able to speed up my process while still being able to defend it?
Yeah, I can jump in again, Steve, if you're okay with that.
Sure, yeah, go ahead, Stephen.
I agree. I think the TAR iterations of 1.0, 2.0, 3.0, they have gone through a bit of their tried and tested. There's a level of acceptance that's at a standard level people have been comfortable with, and there's black letter law around it, right? And I think Stephen can absolutely attest to that. So to the extent that you're able to continue to document your process, and if you're going to come at it with some creative tools or a creative process, just make sure you can be fairly transparent and also defensible. You don't want to be too far on the edge to make it a discovery issue. I think that can be problematic, but I've definitely seen some very creative approaches of minimizing the sheer burden of trying to get through vast amounts of data and still accommodating a level of strategic transparency with either disclosures to the government or to the other side, your opposing counsel, so that everyone feels like you're doing your best and you're doing a reasonable effort. And I think a lot of it helps when you don't just kind of implement one process that says we're eliminating all documents, we'll let you know whatever comes out. It helps to say we're doing validation and testing in the back end. I think that really rounds out the story. So I think that's what we try to do when we're part of these conversations, is say, look at the bigger picture, refine it to where there's a story of, we took a larger portion of data, we did some natural efforts in culling, and then ultimately we took this approach to review the documents, and we did these tests in the background to validate non-responsive sets, validate other types of QC measures.
Yeah, I think that's right. I mean, and I think part of what Sean was asking is, how do we actually implement that? And I mean, it changes from case to case. I think most folks are using, TAR 2.0, 3.0, in addition to keyword searches and other culling methods. Whether they're doing TAR first before they're running their keyword searches or after. It really depends on the case, depends on the context, depends on the cost associated with it. So, I mean, we're all, trying to figure out what our reasonable procedure is with respect to implementing these technological advances and dealing with the technological advances from the outside, which have created more data and more data types for us to deal with.
Excellent. Thank you, Stephen. Yeah, I think it's a good thing to keep in mind, right, as we evolve with this. And, next 2 or 3 years, right, if we follow Moore's law, we'll keep jumping, right? I think one of the areas there that we want to make sure we hit on, right, is it's not just AI, not just LLMs, but, really, we're beyond the pandemic, but not, right? There is this kind of remote collaboration. So how do you kind of each of you view using the cloud-based solutions, kind of improve that collaboration and accessibility kind of in a remote environment, right? Has it helped your workflow? Has it hindered your workflow? What are some tips and tricks there that you're kind of seeing that are working out well for you as lawyers kind of consider how they're approaching discovery in what really now is a very kind of distributed work environment?
Well, I can answer that from my point of view. These cloud-based solutions and remote solutions, I mean, they've been around for a bit. It does create some difficulties in managing a large eDiscovery project. You're not having your team of associates in the office on the same floor where it's easy to just kind of speak all the time regarding the documents they're coming across, the search terms, the noise, and the adjustments that can be made. So, I mean, we've had to adjust in connection with document review, but just in general with having, remote attorneys that we're dealing with to be able to implement sufficient controls to monitor and to, provide the correct guidance and instruction to, create a reasonable work product.
I'll chime in, piggyback on that. I think the conversation around hybrid support and or working in this kind of new paradigm have been just an ongoing challenges for anyone that has a team that they're working with. I know for us, we have 5 total managers in the kind of management team that oversees the 30 some odd people that are on the team. And we're routinely talking to each other and to our team members about engagement, talking about, what does it mean to collaborate? What does it mean to operate in this new kind of functional method in which we're communicating when we're used to being in the office and having water cooler chat every day. So those are things that we've tried to be very intentional about our meetings. That's been a big part of it is, make sure there's strong agendas that are thoughtful and that we come out of the other end knowing that we've got actionable work. The firms decided to go with a PM platform, and we've got a project tracking platform that helps kind of collaborate our space a bit more and centralize the tasks across the team, so creates a little more visibility so we can help resource manage across the various projects. And it comes down to just having real good connection with the engaged team members on your team, and then continuing to have that dialogue if people are getting a bit stranded and or siloed because of the nature of the work. So that connectivity, we're trying to still evolve around that as it pertains to replacing, the dynamic of everyone in their office 5 days a week. Zoom's helped a lot.
Right.
Excellent. Thanks, Stephen. So I would say, as we kind of look, the continuity of these time test fundamentals, Stephen, we want to go ahead and move on to, really the collection review of ESI as we referred to earlier. We can kind of get into the meat of this. So really, what do you kind of see as the gold standard here, right? What is the importance of identification and collection, and kind of who drives that approach to a collection?
Well, before we move on to collection, I just want to hit a couple of legal high points in the TAR world. Number one, as Stefan alluded to, it is black letter law. As Judge Peck has said at least once, that where the producing party wants to utilize TAR for document review, the court will permit it. Judge Peck also he refers to it in the Rio Tinto case, which is mentioned on the slide here, eDiscovery in the digital era. He harkens back to his original TAR decision, the De Silva Moore case, which was a 2012 case. But he makes a universal statement about how do we evaluate these tools and technology. And he states, as with keywords or any other technological solution to eDiscovery, counsel must design an appropriate process, including use of available technology with appropriate quality control testing to review and produce relevant ESI while adhering to Rule 1 and Rule 26B2C proportionality. So the judge is explaining to us that these new tools are a welcome tool in our toolbox for document review, but we can't just wholesale use them without evaluating an appropriate process and doing quality control. I also want to point out what the Rule 1 that the judge is referring to is Rule 1 of the Federal Rules of Civil Procedure, which state that the aim is to secure the just, speedy, and inexpensive determination of lawsuits, which kind of works together with the proportionality doctrine of Rule 26. I also want to point out with respect to TAR, although the case laws have said that it's acceptable, there are judges that have even recommended that the parties use TAR to resolve discovery issues. I don't believe it's on the slide, but there's the case Youngevity versus Smith, which was a class action, which involved an improper data dump and a withholding of about 700,000 documents. And the judge in that case, it's a Southern District of California case, recommended that the producing party utilize TAR and pay for TAR to provide for the relevant data set to the receiving party because of the improper data dump and withholding of documents. So it's interesting, and it's nice to see that not only is it acceptable, but judges are even recommending it in certain situations. And one additional practice point for folks here, I'm in New York. I don't know about other local jurisdictions, but the New York state courts have codified their approval of TAR in the uniform rules for the Supreme and county courts. The rule states that the parties are encouraged to use the most efficient means to review documents, and it goes on to say that such means may include technology-assisted review, including predictive coding in appropriate cases. And one more point I do want to hit on before we move on to the gold standard. We've just discussed the mountains of data that we're going through, these new tools that we're trying out, and of course doing quality control and making an appropriate evaluation and plan on how we're using it. But of course, there's concerns, and one of the major concerns in producing this, voluminous piles of data is privilege. So one question comes up: is there some way to ensure that I'm not going to disclose or waive privilege with respect to these mountains of documents that I'm going to produce? And I have to point out that there is Federal Rule of Evidence 502D, which is a great tool to have in your toolbox if you can get the order. It's basically a get out of jail free card that the rule states that a federal court may order that privilege protection is not waived by disclosure connected with litigation pending before the court. And the way that it's been applied is parties will ask for it or build it into their ESI agreement or their confidentiality agreement, or even some judges have put it into their case management order to implement this order to make sure that if parties inadvertently disclose documents in connection with discovery and document production, they have not waived privilege. And this is better than the 502B, which is inadvertent disclosure, which requires you to show that you took reasonable precautions to avoid production and that you rectified the error promptly. Rather, 502D is no questions asked. If you found that you've produced a privileged document, you can rake it back, and you have not waived privilege with respect to that document. So it's a great tool to have out there. It's something that you should negotiate with your adversary to have it so ordered. And I mean, take a look at your case management order in your case. The magistrate or district judge may have already put a provision in there to so order this federal rule of evidence section.
All right. Thank you, Stephen, for clarifying all of that. You know, as we kind of pivot to kind of gold standard on kind of collections there, I guess, Stefan, from the eDiscovery side of things, do you see kind of forensic collection as always necessary? I know we kind of talk about, identifying the best approach. So I'd say, how do you see it from kind of the lit support side, where you're supporting?
Well, I think for things that are kind of established, I think the one part that still kind of requires a continual forensic analysis and understanding, because those tools themselves kind of work in a particular way, is the mobile market, right? So if it's a shift of the phone, a shift of the iOS, those are considerations that we usually go to, a trusted service provider such as Conduit, to go ahead and kind of be the one that's going to certify those results, have the right tools in place to grab the data. We do collect our experiences. I do suggest that, creating some type of knowledge portal that says, let's look across the various data sources that are evolving, whether it's the mobile spectrum or the cloud-based spectrum, and understand what tools are being used out there and best practices in using those tools. Because you'll learn something as you go across matters, either different nuances with different types of data, or tips and tricks of the best way to collect the data, understand the data, and then obviously make it available for review and production. So I think there's a facet of, if you're speaking forensic, of let's make sure we've got kind of a mature tool that's looking at this and it's not just willy-nilly grabbing data and throwing it through the process. You just want to, again, go back to our earlier statements, test it, kind of understand it, and do what's reasonable ultimately.
Thanks, Stefan. And Stephen, what would you kind of view, right? What is spoliation, that's standard, and how do you avoid this spoliation of data?
Well, I mean, the standard, let's see if I can get you guys. You have a duty to preserve. So the duty is set forth in Rule 37, and you have to take reasonable steps to preserve documents. And if you don't do that, you're going to run into an issue later on. When does that duty to preserve begin? It's once the party reasonably anticipates litigation. At that point, you have to suspend routine document retention and destruction policies and hopefully put in place a litigation hold. Now, spoliation, now this is a quote from the Zubalak case, has identified it as the destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. So that's spoliation. For a party to actually obtain a spoliation sanction, the standard that they have to meet is they'll have to show that by preponderance of evidence that the party had control over the evidence, had an obligation to preserve it at the time it was destroyed, and that the records were destroyed with a culpable state of mind, and that the destroyed evidence was relevant to a party's claim or defense. So in that situation, you can end up being sanctioned in a couple of different ways. The lighter sanction, if the party seeking spoliation can't demonstrate a culpable state of mind, but can demonstrate the other elements, they can obtain a sanction to at least address the prejudice to the party that has not received the evidence that was otherwise spoliated. However, if the receiving party is going to be able to demonstrate bad faith or a culpable state of mind, then the sanction can go as far as an adverse inference or even a default or dismissal of the case. So that's the general framework of spoliation. How do we avoid falling into that issue? It really kind of goes back to the beginning. It's identification. Where are my data sources? Who are my custodians? Who is holding the data? We have to get out a litigation hold letter and reach the right people. Who are the key players in this litigation? In addition to the key players, we're going to do multiple interviews. We're going to discuss the case with management and get to the point of discussing it with the IT professionals. We're going to want to know, where is the data residing? Are there policies for retention and destruction? Is there any data that is going to disappear on us if we don't act on it? And we'll have to quickly determine whether it's something we need to collect in connection with the case. In addition to just sending out a litigation hold letter, our duty goes beyond that. We have to reasonably monitor the collection process and preservation process, which means following up with the client and the key people at the client to make sure that they haven't destroyed any evidence or lost any evidence or allowed any evidence to be deleted. So you have to continually follow up. Otherwise, you may fall into this issue with sanctions. And there's a couple of cases out there. I think the Qualcomm case is identified on this slide. It's an interesting case, and it's a terrible case for the attorneys involved. The attorneys themselves were sanctioned in the case, and part of the reason, as the judge points out, is lack of communication between the party and the lawyers. But what happened if you read the appeal and the judge's withdrawal of the sanctions later on, the judge identifies that the attorneys kind of fell victim to their own clients' assertions regarding whether documents existed or not, and it puts a lot of pressure on us as lawyers and practitioners in this field to investigate, to carry out our duty to reasonably investigate these data sources and locations for documents beyond just getting a yes or no from our client, to make sure that we have collected everything. We've collected all the relevant and responsive documents. To a certain degree, we can rely, but we should try to verify as best we can, and we should continue to document our processes. And this really just goes for any sort of evaluation of eDiscovery process. Document what you're doing. Document why you're taking these steps. You may have to demonstrate it later on in the case why the way you acted was reasonable. Why was this collection method reasonable? We didn't engage in a forensic collection because the amount in controversy was so small and the relevant documents were so limited. We just did a zip file of loose files on a server, and we grabbed a PST, and we did our best to preserve metadata. And maybe that was proportional to the needs of the case. And maybe we've met our duty of reasonableness associated with that particular case. But you will have to evaluate all these steps that are taken through that lens of reasonableness, proportionality, competence, under the model rules of professional responsibility, we have a duty of being competent, and the model rules specifically point out that we have to be competent regarding the technology that we're using or not using. So we have to consider all of these things in connection with our decisions and document it. Make sure we know why we're doing what we're doing, not just because we did it last time, but we have a good, strong reason that is defensible. And I wanted to say this before, that bullet point, ensuring defensibility. I mean, there is no one simple trick to ensure defensibility. You have to evaluate all of these different facets, all of these foundational premises to make sure what you're doing is reasonable under the circumstances and is defensible, because you're going to have to defend it yourself to your adversary or possibly ultimately in front of a judge. So make sure that you are on good footing for your reasoning behind it, whether it's because of proportionality, because of the means of your client and their inability to maybe carry out a certain technological collection that is otherwise unavailable. Document and be ready to defend what you've decided to do.
Thank you, Stephen. All excellent points to kind of keep in mind, right? As we kind of could say, lean into that process, be able to document and make sure we're utilizing those tools that we've kind of built up over the life of this industry. So as we try to wrap up here before we get to some of the Q&A questions, I guess, Stefan, any advice, on kind of successfully integrating technology into the eDiscovery process, or best practices, or any lessons learned, or any follow on there to what Stephen, the points he made?
Yeah, plan, test. Always be purposeful and thoughtful. I know they're very generic terms, but they are the fundamentals of how we try to approach establishing a process with new technology, and then ultimately communicating some transparency to all the parties that, this is something we're trying to, if it's a new tool, if it's a new, approach, that we're exploring this, and hopefully it brings the value that we're expecting and or addresses a risk that, that we've seen before. So I'm going to completely echo Stephen's thoughts around document, and it can be a real challenge, inherent challenge, as things are moving so fast to try and document everything, but just try to look for workflows that will make accessibility to checklists and the recording of information. I do think a smart tool that allows you to collaborate and record information as the scope changes across a project, whether that's search term iterations or the scope of data that's being collected or considered. But ultimately, you want to have a map that kind of describes how you got here, for all intents and purposes, so that you can explain yourself. And that's what defensibility is, right? And ultimately, that's all going to be governed by reasonableness. I did want to say the other thing is a diligence component relates to just timing. So it's important that you're asking these questions early. Again, prove things early so that you can document it. If you're asking these questions 6 months, 9 months later, the very nature of this type of data that's created now is it disappears. It doesn't always stick around forever, at least for specific data types, right? Like the ephemeral data sources and or the data governance program you have in place for your organization, because most organizations don't want to keep data forever, so you just have to be very cognizant of your timing of, again, when you're aware of anticipating litigation, and then ultimately when you start acting on it, and so that, again, supports your story.
Excellent. Thank you, Stefan. Stephen, any quick thoughts on this before we hit the Q&A?
I just want to make one more point as far as a legal issue for my trial practitioners out there. Think about your evidentiary issues, any issues of authenticity of documents or ESI. The judge in the Nichols v. Noom case pointed out that there may be some issues with authenticity with the links versus attachments in those Google emails. So you want to keep in mind, do I have a witness that has personal knowledge who can testify regarding this particular ESI document? If I don't, do I have maybe an expert who can explain, how this was maintained, how it's held, where it came from? If it's not your document, it's your adversary's document, and you're going to have difficulty authenticating it, maybe you want to make sure you have a 30B6 witness on behalf of the company that maybe is your adversary, somebody from their IT or technology department to explain the ESI so you can make sure that it's admissible. You can also consider self-authentication in connection with certain ESI, where you can get certification from an expert. There's a process associated with that where you'll have to disclose it to your adversary and they get to review. A lot of times, folks in my experience, use requests for admissions to have a whole bunch of requests for admissions regarding the main documents in the case to admit that they're authentic and admissible and developed in the ordinary course of business. I think that's been one of the methods for years, as is the method of just stipulation, because there's the what's good for the goose is good for the gander legal theory, which everyone on both sides may have an issue with ESI, so you may be able to just stipulate to that. So I just want to bring up, be aware of evidentiary issues. They may be sneaking around with respect to ESI, so be aware.
Thanks, Stephen. I think that helps address a couple of the questions, right? Especially around linked documents. What are the limitations? And kind of the exceptions. Somebody that in the audience asked, if you are deadening links, are you altering the metadata, right? And what is the ways we need to consider that, along with, especially with cloud-based collaborative platforms. Documents are continuous, right? Data can be updated, right? So really, I think was you're kind of asserting there, right? Get people that can attest to things, right? Sign off on it, document everything you have. And I think that really a lot of this is kind of new and out there. And I think it's just being really careful and having a process for how you're addressing it. And then really the last question out there, right, is, the Enron data set was good for a very long time, right? But as we kind of move into emojis and some of these things, do we have any gold standard out there? Stefan, I would say probably not. I know as a service provider, we kind of develop our own test set. So, real quickly, I guess, is there anything you guys can think of that's out there to advise, this group on that's a good test set, or is it just building it in-house for the time being?
Yeah, publicly available. I know that some have gone down the path, I think, of again, doesn't have the modern collaborative chat data as much, but I think the Hillary Clinton emails and/or a segment of the opioid disclosures has a pretty heavy document set. It's not, from my understanding, and people can absolutely correct me if I'm wrong, nothing that has a huge set of collaboration chat data. Absolutely looking forward to someone to prove me wrong, or when it eventually, some level of public data becomes available, that'll be great, because I think dealing with those types of challenging data types is very important, as it's just going to continue to grow, and well, we know it's actually superseding email itself.
Stephen, any quick thoughts there before we go ahead and hit around the horn here?
I mean, to echo what Stefan had said, I mean, the data sets and the sources are just changing. I mean, we talked about it a little bit earlier. How are we adapting to remote work? I mean, all of our clients are as well. With Zoom meetings, Zoom recordings, there's a lot of audio data. There's a lot of, different data types that we just don't know how to deal with yet, and we just have to take it as it comes and apply these fundamentals to find that sweet spot of reasonableness and proportionality, and make sure that we have something that we can defend in front of our adversary and a judge.
Excellent. Thank you, Stephen. Thank you, Stefan. And at this point, I will hand it back to Michael.
Awesome. Great presentation, guys. Thank you, everyone, for joining us on the ACEDS webinar channel today. Thank you, Stefan, Stephen, and Sean for a great presentation. And thanks, of course, to our partner, Conduent. You can learn more about Conduent at conduent.com. Add momentum to your mission, a leading BPO provider in the space. Thank you so much, everyone, for joining us today. Please visit aceds.org for a complete list of upcoming webinars. Have a great day and be kind to one another.
Thank you.
Bye now.